Good morning or afternoon, everyone. I hope everyone is doing well. I think we are ready to go and get started. So thank you for joining us today. We are going to be talking about the 50th anniversary of the Copyright Act and what has happened since then, and a few of the things that we think are coming after. And it should be quite the show, because in preparation for it, we've had conversations and realized we could be probably talking for months. And so we're trying to fit that into 1 hour. So we'll see how this goes. I'm Katie Rowland, and I am General Counsel here at Copyright Clearance Center. And I'm happy to have my panelists here, my speakers here in this, I think, oh, there goes Pippa. Pippa comes back. So before CCC, I worked at the Copyright Office with David, who I'll introduce first. So David Carson, he is most recently one of the officers on the Copyright Claims Board at the Copyright Office. That's just the latest in an illustrious career of copyright. Actually, David hired me at the Copyright Office a very long time ago. So before the CCB, David was also general counsel at the Copyright Office, and he also worked at the PTO for a bit. He also has a lot of private practice experience, including at IFPI and then at a law firm when he was in California. So thank you for joining us, David. Next up, we have...
Glad to be here.
Great. We have Susie Wilson. So Susie was also at the Copyright Office, so we are lucky to have two former general counsels here in our call. And Susie was general counsel at the Copyright Office, overseeing a wide variety of legal matters for the office during quite the interesting time period. And before that, she had a lot of other copyright-related matters. So she worked at Disney, where she was heavily involved in the IP. Before that, she was a partner at law at Arnold & Porter, where actually I met her. She was another former boss of mine from the past, and just an expert in a whole variety of copyright-related materials. And finally, and last but definitely not least, we have Pippa Loengard, who is executive director of the Kernighan Center at Columbia. And she is also a lecturer in law at Columbia Law School. So she has a lot of teaching and a lot of research, a lot of kind of looking at visual arts especially, but also talking about moral rights and all of those other things. So she is also an expert in her field. And welcome to you all. Thank you all for being here. I think Pippa,
Thank you.
Oh, great. So thanks everyone for being here. Let me see. Make sure that if anyone has issues hearing me, let me know. Hopefully, if I talk slower, it will be better. Sometimes I talk a little too fast. So we have so much to talk about here. There are so many different things. And I think we wanted to start with kind of what are some of the things that the 1976 Copyright Act changed. So before the 1976 Copyright Act, there was the 1909 Copyright Act, and before then there were other ones, the first one being the 1790 Copyright Act in the United States. And throughout this time, we've had just a ton of change. So with that, I wanted to know kind of what are the biggest changes that you wanted to talk to? And I think maybe I will start with Pippa. So Pippa, do you want to pinpoint one of the things that that 76 Act brought?
Yeah, absolutely. And thank you to everyone at CCC who has made this possible, and Katie, and I'm honored to be here with David and Susie. The role of, I always think of like publication being one of the major changes between 1909 and 1976 that really not only changed the basic rules, but also changed in many ways the tenor of the 1976 Act and copyright's role today. So I'm not sure how many in our audience know about publication under the 1909 Act. It's probably not something that comes up in your daily cocktail conversation. But so many of the rights afforded copyright holders under the 1909 Act were dependent on the publication status of the work. And the definition of published was so unclear. The term wasn't defined, only date of publication was defined, and that's the date the work was reproduced or sold or publicly distributed. Again, what does that mean? And the courts had interpretations of that, obviously, but they were fluid terms. And unpublished works could still get many benefits if they were registered, although you didn't have to register. Conversely, unpublished works, which were not registered, could, under common law, have an infinite term of protection as long as they remained unpublished and unregistered. So there was like limited publication. There were so many different variations, right? So it's no wonder to me that the drafters in 1976 of the Act were thought that maybe publication was not the best benchmark on which to base rights. And also they felt the need to define publication in the 76 Act, which is very helpful. But I think there's a reason other than this confusion that moved publication from being the hallmark of the Act. And so publication indicates that the publisher is the, I'm getting an error button. Okay, that publication is the basic, is the publisher is the basic focus of the Act, right? And so the economic driver of the work gets precedence, whereas the 1976 Act is really focusing on the author. And that's obvious in many ways, all right? Not only in that you get a copyright upon creation, so it's in the author's hands that they have a work that's eligible for copyright, not on publication, but also obviously in other ways, such as the bundle of rights that were expanded and the term being based on the life of the author. But anyway, that's for another day. But I think publication really made a point of potentially expanding the public domain by allowing creators, by allowing other creators, secondary creators, to have a better sense of what was under copyright and what wasn't, what the term was, what the penalties were for infringement, etc. And I think it allowed more works, since there wasn't this long term for unpublished works and unregistered works, to enter the public domain. So I think publication really changed a lot in copyright.
Thanks, Pippa. Susie, what about you? Do you have a specific topic for this?
Yes, and I want to pick up on the theme that Pippa identified, which is you go from a 1909 Act that may not have always been very pro-author in some ways to an approach that was much more pro-author and trying to simplify some things. But what I wanted to talk about was the divisibility of copyright. And again, for folks who don't know, under the 1909 Act, there was this doctrine of indivisibility, which is meant you had this bundle of rights, but if you were going to assign it, it had to be all together. You couldn't pick apart those bundle of rights. And one of the things that they did in the 1976 Act, and this is in section 201, subsection D, subsection 2 of D, is to allow an author the power to say, well, I'm just going to assign this piece of my rights over here and this piece over here. And that really allowed for kind of an explosion from an author's perspective of the power of what you could do with your bundle of rights, because it meant that people, the market could compete for each one of those bundle of rights. And that gave the author more power to decide where they wanted, if they wanted to assign part of the rights and maybe keep part of the rights to themselves. And that has also meant that we've seen kind of, the maybe an adaptation of a book here, but the publication rights somewhere else, and even merchandising rights somewhere else based on characters. And so I think from my perspective, that was a huge change and really shifted to a very pro-copyright also marketplace. So that's what, and I think, Pippa, that was very much in line with what you were talking about, is let's kind of move this to much more of an author's perspective.
Thank you, Susie. And it's something that we take so much for granted these days, that you can, assign these rights over here. You could assign your reproduction rights here. You could do a territoriality. You can do all of these things now that make it so much more flexible. Wasn't always the case. So thank you very much.
I was going to say, I will say the flip side of that is if you're trying to figure out where the rights are, it might make it a little bit more complicated.
Yes. Your record keeping. So if you are working in a company right now, I think any of us who've been a lawyer at with an outside counsel to a corporation, you will have encountered probably this problem of where is that assignment? Where is the specific language? Do you have it in writing? So it is the good and the bad, but it brought flexibility, but also requires some additional, record keeping and paying attention to where things are. Thank you, Susie. So David, what about you? What is the piece you would want to raise?
Well, as Pippa and Susie have already demonstrated, the 76 Act was in many respects more author-friendly than the prior Copyright Acts. I thought I'd talk about a couple of related issues, because you really can't understand one without the other, on how duration of copyright was addressed, as well as how termination rights of authors were addressed. Up until the 76 Act, copyright was always a two-term proposition. You had an initial term, which from 1909 on was for 28 years. And if the author or copyright owner chose, they could apply for a renewal, which they would get, for another 28 years. So a total of 56 years of copyright protection. That one of the features of that two-term system was that if an author had assigned the copyright to somebody else, which is very often the case. For example, if you're an author, you're probably not going to publish your book on your own. You're going to go to a book publisher, and that book publisher will publish it and distribute it for you. And the book publisher is probably going to ask you to assign the copyright. In other words, sell your copyright to the publisher, who will then pay you royalties for the sales. The good thing about the old system was that the author had the right to recapture that copyright at renewal time, because at the 28-year point, you had to renew the copyright, and it was the author who got to renew it. Over time, however, that became, as a practical matter, not so much the case, because publishers, and when I talk about publishers, I'm not just talking about book publishing, it's music, sound recordings, motion pictures, and so on. All works more or less the same way. The distributor, the person who's selling your work, is going to usually get the rights from you. And they would put in their assignments a grant of the second copyright term as well. And while one reading the act might not have thought that they could get away with that, because supposedly you get the right to renew it, the Supreme Court in 1943 said, nope, if you told the publisher that you were going to give them the rights to the work at renewal time, you're bound by that. So if you were still alive at the time of renewal, you didn't get the right to renew it. If you'd already assigned that right to somebody else. The 1976 Act, we got rid of the two-term system. We moved to a system where the basic term is life of the author plus 50 years. That's clearly more author-friendly. It's a longer term. It ensures that the author is going to have the benefit of the copyright for the author's entire life, and then it'll be around for quite some time thereafter for the author's survivors. So from an author's point of view, that was a much better deal. But of course, without the renewal term, you didn't even have a hope of getting the rights back. That's where a termination right came in. In order to take the place of the renewal right, Congress decided to give authors a right to terminate an assignment. There were two different rights. I'm going to talk about the principal one, which was a right to terminate an assignment 35 years after the assignment was granted. So you assign the rights to a publisher, and 35 years down the road, you're not happy with the deal you made. The book did much, much better than you or the publisher thought it was going to do, and the publisher was getting a lot more out of it than you were. You want to change the deal. You can terminate those rights, and the publisher, usually what happens at that point is the publisher comes back to you and you negotiate a new deal. But giving you the right to terminate it, which you can exercise, puts the ball back in your court and gives you control over it. In principle, that's that works out very well. In practice, maybe not, and we'll talk about that a little later.
Thank you, David. So it seems like overall, the 1909 Act kind of had more hurdles for authors to go through to keep their protection, to figure out what's going on here. It also had some benefits of certainty, right? But the certainty was kind of at odds with the flexibility and the protections that the author community wanted. So it seems like, it went across. It was, took, by the way, many years to get to this point. 1976 Act, the negotiations probably took like 20 years before they actually got it going. So it is really a bill of compromise. And so you see that kind of, what are the trade-offs? We're getting these protections, we're losing some of the certainties, we're more flexible, et cetera. There are other other things that the 1976 Copyright Act changed, but we are going to sail on through to see what are some of the things that have really kind of evolved since 1976. So 1978, January 1st, we've got the effective date. Everything is kind of hopefully going along as we think it should. And then we've got 50 years. What has happened? Like what has kind of survived? What has changed? What has evolved? And I think one of the biggest issues that we've come across that has kind of stayed the same, kind of been flexible, it's kind of, one of these things that's a perennial topic at the Copyright Office, but maybe not elsewhere, which is copyrightability. So copyrightability is something that's very important in copyright law. I would say until the past 5 years or so, no one really cared so much about it. We did at the Copyright Office when I was there because we had to deal with it all the time. But most people thought the bar is so low, you only need a modicum, a spark, what's that? That's nothing. So most people thought basically everything was copyrightable. But now we're in the age of AI, which we'll touch on briefly later. This topic has really come roaring back. So Susie, would you mind kind of talking to us a little bit about copyrightability and how it has evolved and been working since we had the 76 Act come into effect?
Yes. So, and I also know that everyone else on this panel will probably have thoughts on copyrightability as well. That in some ways, this is part of the reason I find this interesting is we've had copyright since the beginning of our nation, and yet we are still having open questions and sometimes disagreements about what is copyrightable and what is not. And since the 76 Act, one of the things is, although the 1976 Act tried to make it very clear that it had to be an original work of authorship, we still had in certain courts an application of how hard you worked on something could establish copyright, even if it wouldn't otherwise be copyrightable. And I think that probably not everyone, but a lot of people listening are probably aware of the Feist decision, which dealt with your telephone, your directory, your white pages, and whether or not the listing of the names and numbers, back when we had white pages, there were probably people listening who are not aware of this, but we used to have yellow pages and white pages that listed everyone's phone numbers. And a provider of the local white pages claimed that someone had copied their white pages, the listings of basically the facts of people's names, the city they lived in, and their phone number. And that actually went all the way to the Supreme Court, for the Supreme Court to finally, in 1991, to say that a core concept of copyright is there has to be originality and creativity, and that is not the same as the effort the author put into something. And so even if it took a lot of time to put together all those names and addresses, they are at bottom facts. And the compilation of those facts of simply being an alphabetical listing did not have significant creativity. And I think getting away from this idea of this concept of sweat of the brow could be enough to get you over the line for copyrightability was important. But when you think about it, this really got fully clarified in 1991. And as Katie mentioned, at the Copyright Office, in some of the appeals around registration denials, the office will continue to see people arguing, it took me a long time to make this, even if what was made was not something that is subject to copyrightability. And so that happened. And then in addition, over the years, we've had some statutory changes. We've had architectural works added. We've had the expansion really through the courts of applying copyright to software and how that's continued to expand. And in a way, it means while on one hand, the Supreme Court in Feist narrowed and clarified what could be copyrightable and the need for original authorship and that spark of creativity. On the other hand, we also have a continual expansion of the type of works that will fall into that bucket. And it has led to, I think, a world in which copyright is feels much more prevalent in many, many parts of our lives. And obviously software has become a lot of that. But so I think that I wanted to talk about just that's continuing to expand. And then of course, today we have AI, and how do we apply those old principles to this new development? And in looking at the position that the Copyright Office has taken, that merely using a commercial AI system and prompting it to create something does not mean that you are the author of that creation without more. I think that's very in line, actually, kind of with what Feist said. Like, it doesn't matter how many times you're using it and working on that AI system, you're not actually the creator of that end product. And I know that's actually a hot topic these days and can be disputed by some, but I think the Copyright Office position is very consistent with what's come before.
Thank you, Susie. Pippa, did you want to?
No, I agree with Susie. I think it's what's striking is that despite many people's feeling to the contrary, I think that the act is actually proven quite flexible. And considering, I mean, AI is definitely a huge, I don't want to say hurdle, but large development, which will take time to fully understand how we work best with it under the copyright system. But we've dealt with video recording, we've dealt with contemporary artworks, we've dealt with which often aren't fixed or original, and trying to figure out where that line might be. We've dealt with all sorts of technological changes, the internet, obviously, streaming, the whole world that we currently live in. And so I can't believe that AI is something that's not conquerable, despite the challenges that it's clearly posing. It's sort of the inevitable follower to the Narutos of the world. So I agree with Susie that we're doing pretty well in terms of the 1976 Act. Obviously, there's always going to be criticisms and there's always going to be room for improvement. But like we have with every previous technology, we're working through it, both through the court system and through the Copyright Office.
David, do you want to add anything? Oh, you're muted, I think.
It's true that Feist did get rid of what was called the sweat of the brow doctrine, and good that it did. And some of the courts had always gotten it right, some courts hadn't, so it was good that they corrected that. One shouldn't overread Feist, though, to say that that was a very high bar to copyrightability. Feist itself said that you have to show a modicum of creativity in order to meet the threshold, and that's not such a great bar for most works to make. Where copyrightability really has become more of an issue, I would say, is not with respect to whether a work as a whole is copyrightable, but rather in infringement cases, when a plaintiff is saying, you infringed a copyright in my work, courts have to figure out what it is that was allegedly taken from the plaintiff's work, and then ask, is that which was taken copyrightable? And that's where copyrightability analysis really comes into play more often in the courts. It's when you have an infringement claim, when something was taken, but was it just an idea or was it protectable expression? So most of the action in the courts when you get to copyrightability really comes out in infringement cases.
Well, and I think one other thing which David's comment and also Pippa's comment made me remember is also this idea, as Pippa was mentioning, in the art world. And when you have spaces of kind of immersive art and experiences, and which can be in some ways a fabulous idea or experience, but what part of that is copyrightable and what limits are there on someone else simply coming up with a very similar experience, which goes to David's point of, well, is there something copyrightable that got copied versus simply that idea?
I think this is why conceptual artists tend not to even attempt to enter the system, so to speak, because Chapman Kelly being the exception. But the idea of where, I mean, this sort of goes back to what I was saying about publication. Where is that line? And heck, I might not make that line, and it's not worth the costs of litigation for me to try to enforce something that no one really knows where, you know, whether my work would be considered fixed. I think that choreography is something that has been a big help to artists, the ability to copyright steps. It provided a little guidance in terms of what is copyrightable in terms of performance, as Susie was saying. So we get there slowly, but it's a process, right? It's a continuum. So I think that helps. I mean, I was thinking about like how VARA might fit into this, but VARA is so different. I know it's in the Copyright Act, obviously, but it's moral rights have just such a different, it's not really about copyrightability, right? It's about the rights of the author. It goes back to sort of putting more control into the author's hands. And it's always seems sort of out of place in the act. I know that we are not the only country that has it in the Copyright Act, so I'm not suggesting it didn't belong there, but it is sort of a different beast. It would be interesting if we added a right of attribution, for instance, to the bundle of rights, not taking it out of VARA, but expanding it from VARA and allowing all authors that right. That might be a good next step, she said, provocatively maybe, in expanding authors' rights even more than they are today.
Thanks, Pippa. And it seems, you know, copyrightability, when we talk about it, it's so many different things, right? It's, you know, you've got to have an original work of art, fixed and tangible medium of expression. Each one of those is part. So what's original, right? So that's the question of, is it a modicum? Is it a spark? What happens? And then is it a work? Well, do you have human authorship? And that's where when Pippa was talking about Naruto, the famous monkey selfie, or, you know, AI, that's that part. And then, you know, fixed and tangible medium of expression. This is about some of the conceptual art pieces, right? So it really spans so many things. It's not just as simple as copyrightability, but it continues to evolve. And I think that it's continuing to address things that it has been addressing for a while, and people maybe hadn't been as paying attention to them because they were sense-biased. It had been kind of like, oh, you did something, and so you got a copyright. Not really true, but there had been kind of that view until now. So copyrightability, huge issue. We have other big. Oh, go ahead.
Who would have thought that tattoos would become like a subject under Copyright Act, right? These are the things that it really is stunning how we've addressed new mediums, old mediums that suddenly become monetized and therefore worth enforcing one's copyright in.
Yep.
When I also think even about like kind of street art and things that people probably didn't think one way or the other about 50 years ago, and now are recognized as being both copyrightable and of value, and therefore protectable. And the other thing, you know, one of the reasons I think in the area of copyright registration that the question of copyrightability, that the boundaries of it continues to be pushed on, is simply the breadth now of the right of copyright. That one, the term is, you know, now longer than it was 50 years ago, but that also it is different than some of our other IP rights in terms of your proof, right? That you don't have to determine the elements of a trademark or the elements of a patent, but you can prove this is copyrightable, and therefore, if someone copied it, I have my breadth of rights.
Right. And I think that brings us to another issue that's come up over the time, which is infringement. And how do you determine if something is infringing? So, if you are the owner of a copyright and you see somebody using something that you think is based on your copyright, too close to your copyright, the way to figure this out is, is it substantially similar? So in most cases, that is the question. Is their work that they're using substantially similar to what you created? And this has been going on for time immemorial, I think. But Pippa, why don't you talk to us about kind of the evolution of substantial similarity?
Sure, we'll be here till 4. I hope everyone brought lunch. So actually, this discussion today made me do a little more research than I might have in the past. And I think we all default to Arnold versus Porter as the idea of where substantial similarity comes from, although I could find no definition of substantial similarity or a finite point. Although I did go back to an older case, Daly versus Palmer in the mid-19th century, which really lays it out quite clearly, pre-Arnold versus Porter. So thank you for that. I don't know when it will come in handy, but I know at some point someone will ask me about it, probably a student. So substantial similarity, obviously in the news right now with the Sedlick case. Again, tattoos. And Jeff Sedlick's Portrait of Miles Davis, iconic. Kat Von D, an iconic tattooist. No shade on Kat Von D and her mad skills. However, in this case, she copied Jeff Sedlick's work, right? And she was the first to admit that she posted on Instagram a picture of her with the work while she was doing it. This was not a question of did she have access or did she know that she was copying it. That was the whole point. And she in fact traced it. Much like a Raphael would have, with little pinpoints and then brushing over it onto the subject's arm. And so this is a situation where I think to many in the copyright world, this was sort of a slam dunk case. And what's interesting about substantial similarity is a couple things. One is I don't think it really affects creators, okay? I don't think creators are thinking to themselves as they make something, wow, I wonder if this is substantially similar to another work. And that's good because there is no guideline for substantial similarity. It's interesting that the 1976 Act didn't draw any conclusions or address it in any way. Again, I'm not a total expert in legislative history, but I've had some exposure and I have not seen anything and about it. And yet they codified fair use, even though some of the great sages of the 70s were against the codification of fair use. Congress decided that's where they were going to do that. They weren't going to do it in substantial similarity. So it's a good thing that the creators are not hampered by this idea, because who knows if they would be right or wrong. But I think that so it's sort of benefited lawyers because we start arguing about it and get paid to do so. But I think it's a little bit of a double-edged sword, right? It's a standard. As I say, it's not a defined standard per se. It's not a percentage of a work. It's not a specific heart of the work. It's not any of that. It's really looking at the copyrightable elements of the work, and every circuit looks at it differently. Well, not every circuit, but bunches of circuits have sort of clumped together, but looking at it differently. And how do you determine, do you look first at sort of a filtration? You take out everything that wasn't copyrightable, and then you look at what's left, or you look at what was copyrightable, or you look at the work as a whole. There's so many different ways that courts are doing this. So if you look at the Sedlick case, though, like it's the other side of the sword, because there is this flexibility. A jury can look at a work and come up and doesn't have to give an excuse or a reason or anything and just say no. And then this sort of slam dunk case, this what many would say was evidence before even getting to trial, are like, hold on, now what do I do? And I think that's shown, like the tattoo artists community filed a brief in the case in favor of Sedlick, as I recall. Like, we want our works protected. So the problem with substantial similarity is the flexibility. The flexibility is because it's a common law construct. And many would say we need that flexibility because there's such a gamut of works. So substantial similarity is really, really tough in my book as to how you would move forward, if you could move forward.
I feel like we've caught on a theme here where the 1909 Act was more kind of rigid and more certain, but then it would, you would have problems because it was too rigid and too certain. And then 76 Act, we've got more flexibility, more kind of not defined situations, like substantial similarity isn't defined, what is an indirect infringement isn't defined, all sorts of areas where you don't have definition. It allows you to have a more flexible statute that can adapt over time, but you also then have these kind of puzzles. And I think we're going to look at that, kind of contrast that with termination, which I think David will talk to us a little bit about more, because termination has a very specific set of rules that you may or may not be able to follow without, your calculator and an abacus and whatever else you might need, your horoscope. But David, why don't you tell us a little bit about how termination has been working?
Great. And I apologize for turning my video off, but I've been having some difficulty hearing the audio when other people are speaking. So I've been shutting my video off when I'm not talking, just to hopefully increase my bandwidth. And it's helping a bit, although even just now I didn't hear everything Katie was saying about me. I think I know what she wants me to do, though. So termination, yeah, I told you, I gave you the overview of termination. But as I learned in the 15 years when I was general counsel at the Copyright Office, and we constantly had issues with people terminating copyrights or trying to terminate copyrights, it's not as easy as you might think it should be. And, is it what Congress intended? Well, I assume Congress intended the law to work the way that Congress wrote it, but I doubt that I doubt that the members of Congress who voted on the bill, well, let's face it, most of the members of Congress who voted on the bill had no idea there was a termination right in there, not to mention how it was going to work. But I doubt that anyone who drafted the bill recognized how difficult it was going to be, except perhaps for the lobbyists, for publishers and others who wanted to make termination difficult. And they might have said, ha, 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 this isn't really going to be such a problem after all. It is possible to actually successfully terminate a grant of copyright, and people do it every day. But it's not easy. And if you think about who it is who's going to be terminating a copyright, it's going to be an author. And you might think of an author as a sophisticated writer of books, books and literary works, who's very sophisticated, knows how to do all this stuff. Well, maybe yes, maybe no. But keep in mind also, authors in the copyright law are a lot more than that kind of author. They're musicians, they're songwriters, they're people who create all sorts of works. They're not necessarily good at keeping records. And if you can't keep records, you're never going to be able to terminate. And here's why. The requirements for terminating a copyright are incredibly complex. And if you don't get them right, then you're going to think you've terminated and find out that you actually haven't, and you've lost your chance to do it. First of all, you can only exercise the termination right during a 5-year window that begins 35 years after you initially granted the rights to somebody else. So basically, you can terminate between 35 and 40 years after the grant was made. But you have to actually do that more than 35 years ahead of time if you want it to terminate at 35, because that's the effective date of termination. You have to give notice that you're terminating at least 2 years and no more than 10 years before the effective date of termination. So you try to graph that, it's just impossible because you've got this 5-year period in which the termination can be effective, and you've got this 8-year period that starts at least 2 years before the effective date of termination in which you can terminate it. And people blow that all the time. They just don't get it right, and they miss the deadline to do it. They might state a termination date that is a year away, and it doesn't work. It's no good. It's null and void. You have to serve a notice of termination on the grantee or the grantee's successor in title. And keep in mind, 35 years down the road, the person you assigned that copyright to may have turned around and assigned it to somebody else. You may not even know who they assigned it to. You probably do because presumably you're still getting royalties and it'll be coming from that person, but you don't necessarily know. And you have to serve that person whose identity you may not know, with a notice of termination. You may not know the date the grant was given, by the way, because you may not even have a copy of the assignment you made 35 years ago. So several decades after the grant was made, you have to know the date it was made. You have to know to whom it was made. You have to know whether they transferred the right to somebody else. You have to track them down and serve them. You have to record it in the Copyright Office, and you have to do that before the effective date of termination. Who can do it if the author's not alive? And often the author isn't alive. Well, the statute has a hierarchical list of people: the widow, the surviving children, grandchildren, and so on. So you've got to make sure the right people are doing it. If there's more than one author, and often there are, you have to have a majority of the authors joining in the termination, or it's not effective. So there are all these technical requirements, which are just invitations to screw up. And a lot of people do screw up. I got calls all the time when I was general counsel from people who were trying to figure out how they could fix a faulty termination, sometimes from lawyers who really know copyright law, and they still haven't quite figured it out. So it's sort of it's sort of a difficult thing to do. No reason it needs to be that way. The first draft of the Copyright Office made of the copyright of the 76 Copyright Act back in 1964 simply would have provided that transfer of copyright would automatically terminate 25 years after it was made. You didn't have to do anything for the author. It just automatically terminated. The rights came back to you. B was a little bit different. And it just gave you a right to go to court if the original deal resulted in the transferee getting a strikingly disproportionate amount of the proceeds. Let's say that situation where the book did much better than anyone thought it would, and the publisher's getting the giant share of the proceeds. But that first option would have been a better one, and I mean, it would probably be a great thing to go back to that option now and just make termination automatic.
Hey, David, you know what that strikes me? It reminds me of like a lot of provisions which were created to be author friendly and sort of because of knowledge or complicated rules backfire. I think of VARA, which is so misunderstood. I once gave a talk on VARA and a fellow professor raised his hand and said, I know nothing about this and it sounds like gibberish.
Pippa, do you want to mention what VARA is?
It's the Visual Artists' Rights Act, which was it's our moral rights contribution to Berne, so to speak, to the Berne Convention. It's fairly limited. It's only to certain pictorial, graphical, and sculptural works. It's a maze. It involves not only Section 106A, but it involves going to 113D in terms of destruction. It's a complicated mess, and it befuddles lawyers all the time. We're starting to see artists, not starting, I'd say in the past 10 years since 5 Points, artists have been, am I echoing? I'm sorry. Artists have been much more able to enforce it and knowledgeable about it. But I think David made a point that's really interesting, that there's so many things that we try to make author friendly. And some would argue that AI was the same, like not that it's in the act, but you try to be as author friendly as you can, and then either it backfires or some authors still aren't happy, no matter what you do.
And so, and just, I was going to touch on termination. The fact is, the rules are very complicated. And while they aren't author friendly, they're actually not always very, friendly to the folks on the other side, because it is a complicated calculation. And the other point is, which David touched on, that if the actual author is no longer alive, you have to know, who holds that right to terminate, because you may be someone who has received an assignment of copyright and you get a termination notice, and you need to know, is that the person actually who does hold the rights, or is there someone else who holds the rights? And because the person, let's say the scenario is that the author's passed away, one of those author's heirs comes to say, I hold the rights and I would like to renegotiate instead of doing a termination before we get there, or during the windows, or terminate and renegotiate. Well, unless you actually really know that is the only person who holds an interest, you could be negotiating with someone that you still are vulnerable to getting a termination from another person who actually holds the rights. So it's complicated all the way around. And I agree that it'd be nice to just go back to kind of a very more simplified approach.
Thanks.
Oh,
Susie.
one other thing I just wanted to say on the Sedlick case, if anyone is watching, in Sedlick versus Kat Von D, the Ninth Circuit did grant a petition for rehearing en banc, and the Ninth Circuit will be looking at their test for substantial similarity. And so that maybe we'll get a little bit more clarity, Pippa.
Thanks, Susie. And I think for those of you who aren't familiar with the Kat Von D, Jeff Sedlick case, you just search for it, as my kid says, search it up on your search engine of choice, and you will see it's pretty striking. If that isn't substantially similar, I think most copyright practitioners would wonder what is. So take a look at that if you in your free time. So I think we're going to move ahead and talk about the future. So we've seen that the Copyright Act of '76, it's here. It's been here for 50 years. It's still working. It's been amended over time. So we've had a lot of amendments over the time. Susie mentioned architectural works being added. It's been amended for the Digital Millennium Copyright Act. It's been amended to include the Small Claims Tribunal that David was an officer on previously. There have been many amendments, but now we're looking at what is going to be on the horizon. What are the things that are bedeviling us today? What do we think the future portends for copyright and anything of the future? So with that, I wonder if anyone wants to bring up, the most obvious thing is AI. And I actually, maybe Pippa, why don't you start us off with, what do you think about AI and copyright and the future? Break out your crystal ball.
Gee whiz, if this is how you treat your friends. Yeah, so I think I'm going to start saying I think that the best best approach is probably, as we've done with other technologies, letting the courts letting it develop through common law, rather than trying to amend the act, because AI changes so rapidly. And one thing that the Copyright Act has a tough time doing, just because of how the world works, is being proactive, right? It's always sort of catching up. And so by the time a change was made to the act, we would be, in a whole different ball game regarding artificial intelligence. I think, as Susie was saying, sweat of the brow, or maybe it was David, I'm sorry, about how sweat of the brow and AI shouldn't come into play, which I think, under Feist and other cases like that is true. The problem with sweat of the brow and AI to me is such as in the Krish Castanova case, or in some of the other cases that are pending. Is it sweat of the brow to refine your search or your instructions 1,000 times to end up with a product that generated that you intended, or is it not? And I don't know where that line is, to be honest. I don't know the skill that's needed versus and that's sort of what sweat of the brow is, right? Skill versus just effort. And so I think it's going to develop over time as to how much of that prompting is skill versus effort. I think the area where I would like to see legislation in this is not in the Copyright Act, but is in transparency, because I think it is very hard for authors of any type to bring a copyright claim in a situation where they don't know if the AI model was trained on their work. And that puts the parties at an unequal advantage. And I don't think that's fair. So I would say we scaffold legislation around the AI platforms. And then hopefully if someone knows that their work was trained and you've made a well-known work, literary art, whatever, and it pops out exactly the same. If you have the transparency to know it was trained on your work, if you have that information, you are, as the author, at a better place in order to fight that. If you don't have that information, it's really an unfair battle. So I think those are two issues that I'd highlight.
Thanks, Pippa. And David, you might have a moment to tell us what is the main issue for the future of copyright that you might want to bring up. It can be AI, it can be something else.
Well, I think maybe the one thing I'll just mention, since I spent the last 5 years on the Copyright Claims Board, is just to mention a little bit about that and what I think, because I do think we probably need to make some changes in the Case Act, which is what brought us the Copyright Claims Board. Copyright Claims Board, in principle, is a wonderful idea, one that was definitely something we needed to do, which was to come up with a place where people who had copyright claims, primarily infringement claims, that made no sense to take to federal court, which up till now has been the only place you could go with a copyright infringement claim. Because if you've got a claim that's worth a few $1,000s, or frankly, in this day and age, a few tens of thousands of dollars, there is no point in going to federal court because it is going to cost you far more to litigate that claim than you could ever hope to win. And yes, you might get an award of attorney's fees, but you might not. So it's a roll of the dice. And by the way, the same is true for a defendant. If you're being sued for infringement of a copyright where the damages are just a few $1,000s or even a few tens of $1,000s, you're going to pay your attorney a lot more money than is at stake in the case. And it would probably make more sense as a practical matter to just pay the plaintiff what they're asking for rather than pay an attorney more money to win your case. So the Copyright Claims Board is it's a board, it's a tribunal in the Copyright Office. It has 3 people on it who sit and try cases together, mostly infringement cases. 90% of our claims are infringement claims. We've had 2,000 claims filed in the last 4 years since we opened our doors. We made about 45 decisions, I think. You can read them, they're online. I think they're pretty good. I think almost all of them are right. I dissented in one, so I don't think they're all right, but pretty good track record, I would say. And most of the feedback we've gotten is that they're pretty good. The problem is not with the decisions. The problem is that, if you heard, we have more than 2,000 claims filed, and we've had 45 final determinations. It takes a long way to get to the end, and it shouldn't, but it does. And in many ways, it's because Congress micromanaged the entire process and put all sorts of requirements in there which have slowed it down. And we've also learned probably 75% or more than that of our claimants represent themselves. They don't understand copyright law. And you can put up a handbook which explains it all to them, and we have, and they just don't read it. Or if they do read it, they don't understand it because Only a third of our claims that are filed with us make it through what we call compliance review, which is when a staff attorney looks at them and determines whether they've essentially stated a claim. And many times they're not even copyright cases. Many times there's no registration or even application for registration, which you need in order to file. Many times they're claimants against people who live outside the United States, which we can't hear. Many times they try to state a copyright claim, but when you read it, you can't figure out how it could possibly be copyright infringement. We write back to them with an order saying, here's what you didn't have a good claim. Here's the problem. Here's how you can fix it. If you can fix it, maybe you can't because you don't have the facts that would make it fixable. They come back again and they still usually don't get it. And by the end of the 3-strike process we have, 50% of claims still never make it across the door. That's an incredible amount of time on our part. It's an incredible amount of time and effort on the part of claimants who really don't know what they're doing and are never going to figure it out. And the simple solution that I and others on the board, I think, would agree with me on this, think would make a big dent in that, is simply make someone talk to a staff attorney on the Copyright Claims Board before they file a claim. Because the staff attorney can tell them what they need to do. The staff attorney can hear their story and say, here's some problems with that, and here's how you need to fix it. And I think a lot of people would walk away with that conversation realizing they don't have a claim. And they wouldn't bother filing it because they realize they're not going to go anywhere. But instead, we're going to go through this 3-round process of writing orders to them, explaining why they didn't do it. And we could be doing things on the cases that actually are worth hearing. That's the biggest problem. There are many other problems with it. People have to serve the defendant. If you're an individual, it's hard enough for a lawyer to serve defendants sometimes. But you have to serve them the same way you do it in court. For someone who's never even been in court, to have to serve someone is a very difficult thing. And about a third of our cases that are approved for service are never served. There's just
David,
those are just a couple examples.
I'm going to interrupt.
No, I know I could go on forever. I'm going to stop.
But you were very passionate about this topic, which I too, I share your passion about this topic. But we only have a couple of minutes left. Susie, do you think you can say something in a couple of minutes about the future?
Yes. Well, so I guess I will say my hope for the future, which is the area I think that needs to be looked at, is the Digital Millennium Copyright Act. And when the DMCA, as it's called, was passed, there are 2 things in there that were very critical to copyright owners and folks who want to be able to access copyrighted works for non-infringing purposes. One is Section 1201, which is, and this is going to be very jargony, and I direct people to the Copyright Office's website, which is copyright.gov, to learn more, but that there's a 3-year triennial rulemaking process that the Copyright Office must provide under 1201, which is very burdensome, and I think deserves to be looked at again to try to make it more streamlined, both for those who want to take advantage of 1201 and for the Copyright Office itself. But the other thing is, under the Digital Millennium Copyright Act, it was really a balance between copyright owners and online providers in terms of providing a way for copyright owners to quickly get copyrighted content taken down from the online platforms that we all love to use, and gave an incentive for those platforms to have a process to react quickly to take down notices, which we're used to on whether it's YouTube or other social media sites. And that incentive was the safe harbor provision. And the Supreme Court's recent decision in Cox versus Sony, which made contributory liability under the Copyright Act for copyright infringement so strict that the safe harbor has become meaningless, that needs to be reconsidered. And that goes to one of the points that Pippa mentions, that there's nothing in the Copyright Act that says what contributory liability is. And the standard could be determined just by putting that back in the act. So I guess there's a couple ways it could be fixed, but I think that area really needs to be looked at by Congress.
Thanks, Susie. And thank you all so much for being here today. We could probably talk for another year. We could probably talk for another 50 years about this. But thank you very much for giving us your insights about the evolution, what changed, what's been working, some of your hopes for the future. And thanks everyone for joining us today. If you want to learn more about copyright, we're happy to point you to our website. We actually have the best website around, copyright.com. So easy to remember if you have any questions about that. And thank you so much for joining us. And with that, we can say have a good day and we'll talk to you later. Thank you.